Why would a person file a cross-petition in a guardianship? Well, guardianship, and the type I'm speaking about, is in Article 81. Under the mental hygiene law, it's when one adult person seeks to be the guardian of another adult person. So say you have a parent that's suffering from dementia, Alzheimer's, or a cognitive condition. One adult child files to be the guardian. Maybe there's a sibling that does not want that other sibling to be the guardian, and therefore there might be a cross-petition. And then there's a couple of points of friction, because that sibling could say, well, first of all, in my scenario, the adult child is filing for the parent could say, I don't need a guardian, and I have sufficient mental capacity. I do not need a guardian. Or maybe they can't, right? I don't know the condition. It's a fictional story. The other point of friction is that your sibling, your brother, your sister, may be child from another marriage. This person might come in and say, hey, I agree that our father or my father might need a guardian. However, that guardian shouldn't be you. I want to be the guardian. Let me knock out your petition and put in my petition. That's a cross petition. And then that person, there would be a battle of petitioners, and that would be done by witnesses and evidence and testimony. The first petitioner would have to demonstrate their case. They have to make a prima facie case. They have to demonstrate all of the elements of a guardianship, why the person they're alleging to be incapacitated is in fact incapacitated. On this day, this occurred. On that day, this other fact pattern occurred. My parent went missing. My parent left the home. My parent, whatever the allegations are, whatever the circumstances are that caused the filing of the petition. And then that cross petitioner could say, hey, all of those dates are accurate, or I agree, or they're slightly different in this way, except that first petitioner should not be the petitioner. They could be the petitioner, but I don't want them to be the guardian. I would like to be. That's why you might do a cross petition in an Article 81 guardianship. When is a guardian required to file a final accounting in an Article 81 guardianship? Long run-on sentence. That's the way I like to start. So a guardian has the obligation, after becoming the guardian, to file an annual accounting. So every year, by May 31st, an annual accounting. All of the income and all of the outgo, all of the expenses, and what has been done with the funds of the guard. This is funds of the incapacitated person. How has the guardian handled? So if the guardian resigns, the guardian quits, the guardian moves away, the guardian says, I can't do it anymore, or there's a guardian with certain restrictions. Perhaps a guardian, because of their charter, or they're a nonprofit, or even if they're a for-profit entity, they may have a situation where they're only permitted to be the guardian of a person inside of a facility, and if the person goes into the community, they can't be a community. For one of those several reasons, a guardian seeks the permission of the court to resign or withdraw. That guardian has to file a final account, and the final accounting is from the last examined annual account to the date they resign. So if a guardian resigns on July 1, they'd have to account for the period from the last examined approved accounting all the way through June 30th in that example. That's one instance. The second instance, final accounting would be required to be submitted for approval of the court is if an incapacitated person passes away. Same rules apply from the last examined accounting until the date of incapacitated person, direct accounting. And then there might be a small period thereafter that you have to account for. So the guardian paid for funeral service, all of the items necessary to coordination and arrangement of the funeral service, church, cemetery, casket, grave, cemetery plot, all of those things. That would also be in the final accounting. I represent a parent in a guardianship matter, and that person is also represented by attorneys in family court. Now, why is this? Well, the other attorneys were actually this person's attorney first for a child support matter. And the specific type of case is where there's a child over the age of 21. In New York, child support goes to 21, except there had been an amendment to the law, and there are circumstances in which child support can continue until 26 years old based on physical or mental impairment, disability of the child. So if you have a child that's 22, 23, 22 to 26, between those ages, and they live at home within the care and custody of a parent, now that child is legally an adult, but under the care of a parent. It's the same way in New York. Legally, a child is an adult at 18, but the Child Support Standards Act for every child goes to 21. So in some states, child support ends at 18, 19. New York presently has the highest age, and that's 21. I guess they wedded that to maybe drinking. I don't know what the thought was. That was the legislature that made that rule. And the CSSA is the name of the law, Child Support Standards Act. And it goes to 21 in every instance, except when there's an exception. And that had been modified approximately 2 years ago. And, in my office, my associate's handling a few cases where we're seeking support above the age of majority, and even above that, right, because it's 18. But you don't have to take any steps or any large steps to get support between 18 and 21. You have to demonstrate that the person is, a dependent of the parent. Sometimes it's that the person's in school. But if they're not supporting themselves and, they're not in the military or a full-time job, then they're under the wing of the parent and in need of support. And that parent is in need of support because child support actually goes a portion towards, this is the theory behind it, a portion towards food, a portion towards shelter, a portion towards clothes, all of the things that a parent spends for a child. That's anticipated to be covered in the child support, weekly, monthly, whenever it arrives. Now, the meeting was because we wanted to make sure all of the attorneys and the client were on the same page. So we discussed strategy for what was going on inside of the family court case and the overall strategy for the guardianship. And often enough, there are instances where client will be referred to me from another attorney. The ongoing relationship between what becomes a mutual client and the other law firm continues. So, for example, sometimes in a wrongful death, I'll get referred a case because there's an aspect tort lawyer, a personal injury lawyer will be involved in a case, and then they need me to take certain steps in the surrogate's court. Or in this instance, the attorneys were working on the support and increasing it, and I'm going to be working on the guardianship in another courthouse. So there's the interplay of a lot of it. Matter of fact, I spoke with an attorney today, and a person involved in a second marriage passed away. And now there's probably going to be a surrogate's court action. And what this attorney said was now the second divorce begins. I've often thought of the crossover between, family court and then criminal court, family court, then guardianship, but then guardianship at the surrogate's court. I've seen in real-world applications the fighting between siblings and family members continued through those several courts. That's what we're doing for today. Give us a call or look on the website, frankbrunolaw.com.